The contested matters in all the final hearings or trials in domestic relations matters. Yeah. Each party filing a written pretrial affidavit. Yeah. And personal property form shall file and serve the same at 1:30 p.m. of the judicial day prior to the trial. Now, the pretrial affidavit shall be substantially in the form set forth in Exhibit C attached to these rules. Yes. Now, I did read one of these affidavits of personal property. Yeah. I had left a lot of items with my sister Susan Bowers, the same individual that appeared in the Rotarian newsletter. Yeah. As being the impersonator of Marilyn Van Proyen. And it looks like when my wife motioned the court for a protection order, yes, somebody filled out one of these where she got everything that we owned, yes, because it was in storage, yes. See, when you moved to Guam, we only took 15 suitcases, yes, two for each one of us, right, because there was 7 of us at the time, and they let us take an extra suitcase because they were real nice that morning. Yeah, they were. But all the items in that 2,200 square foot, yes, 3-car garage, yes, house that we couldn't take with us, yes, I had my mom and sister move it all to storage. Yes, yes, yes. But when Heidi got back here without the jurisdiction of law, yes, she got everything that I owned. Pooch. Now, obviously, there was no stipulation and order in that. No, no, no. And then when I mentioned that, well, actually the computer was mine, the desktop computer, boom. And then all the herbs that I had saved from the welfare spending, yes. And all my documentation from my various businesses, right. There was this thought that I should have gotten a copy of what it was that they wanted. Yes. Now, when you just issue one of these, well, you can have everything that you want. Yes. Not considering my business files. Yes, yes. I mean, I have a lot of stuff that I would personally like to see. Yes. Now, when I inform you, entry of dissolution decree by declaration of jurisdictional facts. Yes. The respondent or respondent's attorney approves of all the final papers. Including the request for entry of decree and declaration of jurisdictional facts. Yes. Something I would have to do. Respondent's in default, and I wasn't. The decree provides only that relief requested in the petition. Yes. Respondent or co-petitioner joined in the petition. Yes. Now, I don't know what a co-petitioner could be. It's not like you can marry two people. Yes. Now, domestic relations settlement conferences. Yeah. A settlement conference should be held in all contested domestic relations cases, including dissolution, yep. Legal separation, paternity, third-party custody, domestic partnership, marriage-like relationships, or modification of any custody order. The settlement conference shall be held with a court, commissioner, or judge. Yes. Now, domestic relations cases shall not be set for trial under LCR 40B without a settlement conference except in the following circumstances. Now, this was set for trial, wasn't it? Yeah. On December 31st of 2012, you had one of these. Yeah. But the public court record right now doesn't show that. In fact, we're missing number 38 too. So when you decided to set for trial, there was or was not a signature on any of the documentation of myself. The requirement is waived upon good cause shown by a judge or court commissioner, or a settlement is not reached in an initial settlement conference because of a party's violation of one or more provisioning of the LCR 94F. In such instance, a trial date may be set, but a second settlement conference will be scheduled to occur prior to the established trial date. Yes. Once a response to the petition has been filed, a settlement conference is scheduled by noting the matter before the court administrator on the Friday 8:45 a.m. trial setting calendar. Yes. A personal appearance of the parties and their attorneys is mandatory at the settlement conference. Yeah. In cases where domestic violence is at issue or where a party no longer resides within the state of Washington, Appearance may be by phone. In all other instances or otherwise agreed by the parties, appearing by phone is not considered a personal appearance. If the parties do not agree, the requesting party may seek an exception to this rule, filing a motion prior to the scheduled settlement conference to waive the appearance requirement. Now, such motion will be filed pursuant to the terms of LCR 94A. The court will impose a sanction in the amount of $250 against a party who violates this provision. Yeah. Now, I'm just kind of wondering because it says here, if parties agree to reset a settlement conference, they will inform the court administrator of that agreement as soon as possible, but in no case later than the business day prior to the scheduled conference, right? Parties will prepare for and participate in good faith in scheduled settlement conferences 1 week prior to the scheduled settlement conference. Each party shall file a settlement statement in the form substantially similar to the pattern set forth in Exhibit A. Yeah. Now, the settlement statement is intended to provide the narrative and documentary information necessary to inform the court and the opposing party of the submitting party's position on the major issues to be resolved. Settlement statement will not be filed in the court file, but the original will be provided to the judicial officer conducting the settlement conference with a copy provided to the opposing party or his or her attorney. Now, if both parties fail to provide the settlement statement 1 week prior to the scheduled settlement conference, the court shall issue an order which strikes the settlement conference. Yeah. And directs the parties to appear before the court administrator to select a new settlement conference date. Yes. Yeah. Now, I was supposed to give my wife one of these 1 week prior scheduled conference. Each party shall file a settlement statement to inform substantially similar to patterns set forth in Exhibit A. Yes. I had an obligation to make one of these settlement statements. Yes. And my wife had 3.5 months to find me. Well, let's see here. You had a settlement conference setting hearing on December 31st of 2012. Yes. Where she said that she couldn't find me. Pooch. I was living at 1023 Kitchen Dick Road until the 20th of December. Now, I just want to know, did somebody pay Mike Van Proyn to turn the electricity off on me? Yes. So that the pastor of Kingsway Foursquare Church could say, I don't know where Paul is at. Yes. He left all of his stuff in the fifth wheel. Yeah. His passport. Yeah. All of his personal documents. Pretty much everything he owned except for what he took with him. And then when she went to serve me this, in good faith, the settlement conference, settlement statement in the form of substantial pattern set forth, that I wasn't there, and he just lied his ass off. Oh. So he got paid to turn the electricity off on me. 11 days before, yes, the actual settlement conference setting hearing. Yes. So I wouldn't get this statement from the petitioner. No. And then I wouldn't know that I had to make one of those. Yes. Because you didn't serve me at any time. Yes. From September 14th of 2012. Yes. Until the actual date of it. Now, what's really disconcerting right now